welcome again. Without any further ado, I've lost Stuart, oh, there he is. I'm going to hand over now to Stuart Dresner, who's going to say a few words about privacy laws and business, who are co-hosting this event with us.
Thank you, Mark, and good evening, everyone. And I say this date has been selected to being close to Data Protection Day, European Data Protection Day, International Data Protection, North America International Privacy Day. They don't know what data protection is. Anyway, but for us at Privacy Laws and Business and people in your team, every day is Data Protection Day. We just sort of live it all the time. So thanks to Mark Watts and your team here for inviting us to join you in this event. And I'm here with my colleagues, Khan Thomas and Tricia Gellibar. Could we have the next slide? Is anyone moving on the slides? Or have I got to move on the slide? There you go. That's right. Okay. So it's going to be down to 3 minutes. So I'm here because last year, if anyone was here, I covered the first 30 years of privacy laws of business in 5 minutes. So we're not going to do the next 30 years because who knows. But what I can say is that this is our international publication. And when I started in 1987, there were 10 countries, and now we cover 121 countries. Jamaica was the last one to have a data protection law. It doesn't bring peace and serenity in society, but they do have a data protection law. This report is available in paper, electronic format. Some of you get it, and we have regular news update. We do cover the world, Europe, Asia Pacific and the Americas and so on. And we also have a UK edition which started in the year 2000. We cover both data protection and freedom of information and all other bits looked after by the ICO. We also cover Guernsey. It's a little known fact that Guernsey now is going to have its own data protection commissioner. Up till now they've been sharing with Jersey, and Guernsey is going to go separate, and they're going to go all out for EU adequacy. They're not hanging on to the UK's coattails. Even if the UK is inadequate, and Guernsey, they want to make sure is adequate. So that's what's happening there. We follow the news all the time. We attend events like yesterday. I was in the Parliamentary Committee, Science and Technology Committee, looking at algorithms and the underlying issues to algorithms. They're giving evidence to Elizabeth Denham, Information Commissioner, and the new Minister for Digital, it's called just Digital, Margot Janes MP. And so that was very interesting, all about the underlying issues. And of course, GDPR wanted to know the underlying, can you explain algorithms? It all depends on context, how much information you give. Data breaches are everywhere, but we're not talking about this right now. These are one of our round tables. These are, we call Help, not just because it was a Beatles song, because that would date me, wouldn't it? But they were the help, self-help. It would really round a table discussing what people are actually doing. For those of you who don't get around if you do get around the table, the next one is the end of January, hosted by companies, not law firms. And the point here is that when we write a report on that in our UK edition, our red edition, we don't say who said what. So you get a lot of information on what companies are doing in practical terms without revealing the details of who said what. And I see Ellis Parry very kindly here, who, when he hosted at BP, he actually had a circular table. The first time in 30 years we had a company with a circular table giving a literal definition, embodiment of a round table. But not everyone can do that, only BP can do that. Moving on, we have our summer conference, the world's longest running privacy conference, except for the Commissioner's own conference. Some of you have been there and enjoyed the fun there. So this is the title we've chosen for this year, Navigating GDPR, the Art of the Possible. And I met Elizabeth Denham recently, and she said, that's a good title. It exactly frames the situation rather well. So we're pleased about that. It's once again at St John's College, Cambridge, which is a fine classic Cambridge college. And we have published on our website the themes this year, and we're doing gradual revelation. So in a few days, we're going to say who is speaking on what. But these are some of the themes that you'll see on our website. I won't go through them now because I'm only supposed to be keeping myself to 5 minutes. So I will leave you with my contact details, and you'll find them also in your yellow ochre. What do you call that colour? Yellow, right. Yeah, yellow brochures, booklets, books. Yes, so you'll find contact details there. And now that's all I have to say, but I will hand over to Faye Harrison, who appeared representing Bristows at a conference, at one of our conferences about 3 years ago, demonstrating wearable tech by wearing a very highly geared and facilitated T-shirt. We called a smart T-shirt, and I'm very happy to hand over to you, demonstrating the future.
Hi everybody, I'm here today to talk to you a little bit about smart toys. So 2017 has seen very significant growth of the number of smart toys coming to market. Don't know if any of you guys have seen them, but they're expected to increase exponentially over the next sort of 5 years. One study shows a predicted increase of 42% every year in China in terms of shipments for the next 5 years. So it's big business. So what are smart and connected toys? Essentially, they come in usually the form of a doll, a furry animal, a robot, very much aimed at children. And they tend to have the ability to connect to the internet and have the ability to collect lots and lots of personal data. Lots of these toys link to an app on a smart device. So often parents will have a smartphone or a tablet with a connected app that links to their child's toy. In terms of functionality, we're seeing all sorts. Lots of them can use voice command, voice recognition. They can record, they can take photos, videos. Some of them allow maybe the parents or other contacts to message the child via a different device. Some of them you can talk to, have a two-way conversation. And some of the more sophisticated toys even have things like facial recognition. So they really are getting quite clever. And some of the examples we've got up there, we've got the Furby Connect. Some of you may have seen. You can talk to, you can tickle him. He'll learn songs and dances. So he's great fun. The Hello Barbie up there, you can have conversations with, so children can chat with her and their conversations can get recorded. Cloud Pets is a little dog. This is one that parents and other contacts can send voice messages to their children. So maybe if they have told them to go upstairs and do their homework, they can use the dog to tell them what to do. A more sophisticated one, second to the end, we've got the Stormtrooper robot. He's very new. He has capability for facial recognition. He can patrol a room to see if there's any intruders. And apparently you can issue verbal orders so that he can launch attacks, whatever that means. So they really are getting very sophisticated, these toys. So now to the data privacy bit. What are the risks that these toys present? So I think the first thing is the fact that they're collecting the data of children and sending it out onto the web. Obviously, there's immediately an increased risk when you're talking about child data, and the GDPR has specific protection for children's data on the basis that they're less aware of the risks involved, they're less aware of their rights in terms of privacy, and so they are specifically protected. One of the things that I think is quite intrusive for children is the fact that there are these linked apps. So parents can potentially listen to their children, watch them, monitor what they're doing, and sort of this sort of parental surveillance of children that wasn't possible before when they were locked away in their bedrooms. But it gets a little bit more scary when you think about outside individuals, so not parents or other kind of friends and family, but actually a lot of these toys are very unsecure, and they use unsecure Bluetooth networks a lot of the time. And it's been shown that hackers are able to listen in, watch children, and even communicate with them, which is really quite scary. So there's been quite a lot of incidents of testing and kind of data breach with sort of research companies that have looked at these toys. Some of the examples we've seen, so the Furby uses an unsecured Bluetooth network. Hackers were able to get onto the network, play audio to a child, move its eyes around, and they said with a little bit more work they could probably turn it into a listening device. The IQ robot, which is the orange one, second one along, anyone can download the app that connects to, so if you're within Bluetooth range you can start chatting to a child via that robot. The Techstar toucan, which is on the end, was hacked and started squawking obscenities, so you can get it to swear at children. And there's also been a couple of sort of data breaches. So Cloud Pets that I mentioned before, in 2017, 2.2 million voice recordings of children were leaked online due to its poor security. And Also, the Hello Barbie has been hacked, and basically the hackers were able to obtain a lot of information and said that it would be possible to listen to children's recordings again. So there's been a lot of kind of testing that's shown that these devices are really not very secure and not necessarily things that we want to be giving to our children. So what does the GDPR say? I think as a starting point, I would say that most, if not all, of these toys are very unlikely to comply with the GDPR, as they currently are. But there's lots of things in the GDPR that should help if these toy developers are taking note of the GDPR. So parental consent is required for collecting personal data of children under 16, although under the Data Protection Bill in the UK it's going to be 13, so it's a lower age, but it ultimately leaves the responsibility with parents to kind of read the terms and conditions, look at the functionality of these toys, what are they doing, read the privacy notices. And obviously under the GDPR there's enhanced requirements in terms of notice, so the suppliers of these toys do need to be telling the users, you know, what data is collected, what's being done with this data, who's it shared with, and they should be providing all of this information so parents can make an informed decision. We've also got the introduction of data protection impact assessments. So when there's new kind of high-risk collection and processing of data, an impact assessment should be carried out to look at how that affects the privacy of the users. The GDPR introduces statutory requirements of privacy by design and default. So when you're developing new tech, you should have privacy in mind from the start, and it should have inbuilt privacy protections in the technology. Default settings should be privacy positive. It's not on the list, but there's also enhanced security protections under the GDPR. There's a requirement to report significant data breaches within 72 hours, so it will be more difficult for these kind of organisations to get away with it if they are leaking data online and that kind of thing. And also we've got the increased fining powers. So if there is a significant high-profile breach or a big investigation by the ICO, there is the possibility that more significant fines will be issued, which is obviously a bit more of a scare factor for people who are providing these toys. So I guess just what remains to be said is, are people going to keep buying these toys? It's hard to know. Will the developers take notice of these risks? Are they going to start making these toys so they're a bit more compliant? Or is cool tech always going to kind of overrun privacy concerns? Maybe it will take a big high-profile breach or a significant fine before both the developers and the buyers take note. We don't really know, but it remains to be seen, so watch this space. Thank you very much. I think I'm now passing over to Hannah.
Hello everyone, so this one is me, and I'm going to talk about, believe it or not, sex robots. Well, it's a little bit of an exaggeration, and actually this title is slightly because we felt when we were talking through all of the things that people were chatting about in 2017, it felt like you could not turn on the telly without there being some slightly odd, usually Channel 4, Channel 5 documentary about some strange men, usually in the US, I have to say, who'd bought some sex robots. And we felt like, for some reason, that was all anybody was chatting about. But more broadly, I just thought that we thought it would be a good idea to talk about the continuing development between and closer link between sex and technology. And I think that it's generally acknowledged that sex is often actually one of the biggest drivers behind technological developments. So the first one that I thought is worth mentioning is VR. A large amount of the money in developing virtual reality, and it really is the sort of next frontier in terms of technology, is ultimately in porn, in providing a multi-sensory pornographic experience. And then the next one is the Internet of Things, because sex toys now, as with everything else, are now connected so that they can be controlled via an app using your smartphone or your partner's smartphone. And those, again, perhaps alongside with the sex robots, are some of the more niche products, ultimately. But there is still this convergence, I think, between sex and technology in the last 10 years, whether that starts with online porn, sort of literotica, being bought online, e-commerce of sex toys, and then all the way just through to sort of hookup apps and even fertility apps and fitness bands that mean that we are all sharing a lot more data about our sex lives than we have ever been before. And of course, there are privacy implications with that. There are moral, ethical, legal obligations, and anyone who is interested, John Ronson, the British journalist, has done such a good podcast called The Butterfly Effect, all about the impact of online porn. But more generally, in the privacy world, there are risks associated with that. So information on sex life is under the current law and will continue to be special category sensitive personal data. So, okay, a European company collecting this information off you, you can be fairly comfortable that they will need explicit consent with everything to do anything with that data other than, keep it and use it for what you ask them to do with it. But I think there's sort of the first question is, okay, how much do we think that these companies are that interested in the GDPR? Are they EU companies? Are they EU focused? So maybe there is still a question of whether they're going to use that data, maybe sell it or share it with a third party. But then also there's, of course, the question of the bad actors. So there's the hackers. We all saw that Ashley Madison the year before last, how much information that you share online in relation to, and that was, a dating app, okay, a slightly more sort of exciting one, but nonetheless a dating app, could be used to blackmail you, could ruin people's careers when that was revealed. So there are implications. And then there is sort of slightly more just unusual ones when you are leaving a digital footprint. People are, for some reason, very comfortable with leaving a digital footprint, possibly more than they were in the bricks and mortar going to buy something in a shop, even though, in fact, using cash, you can be pretty anonymous there. And I mean, if you look at sort of, to use a 2017 example, Damien Green, the digital footprint that you leave in terms of your sex life can be very damaging. And then also the law has had to adapt with revenge porn, where the fact that in relationships you can also share a lot of information about your sex life, send people photographs, messages, and that sort of thing. And that ultimately, it's very, very hard to get rid of that data. It does stay there forever, and those tech companies, but also other people, can use that against you. So there are definitely privacy risks there. There is a little bit, the last bullet point that I just thought I'd talk about. I think that there is also a huge amount of value in this, and I think it will be very, very interesting. I think it was the 1950s, Kinsey sort of started looking into sex data for the very first time. We didn't know much about something that people don't talk about. There is potential, I think, a potential for huge amounts of value to be found from looking at what people's interests are from all this data which is being collected at an anonymous level, and I think it might give us a greater insight into people's sexuality, what proportion of people even just are gay is interesting from looking at different apps and what people are interested in. So, yeah, I think we thought it was worth commenting on anyway. So I'm responsible for the next one as well, a lot more dreary, I'm afraid, or at least a lot more on topic, the one-stop shop. So the one-stop shop, although I called it dreary, actually I think for a lot of people it was one of the best things in the GDPR and something that people were genuinely really, really pleased about. The possibility, for those who are sort of not quite so familiar with it, the possibility that instead of dealing with 28 or rather 27 data protection authorities and potentially facing 28 different fines, which 28 times 4% starts to look like a really big number, you could just have one. You just have to deal with one data protection authority, your sole interlocutor. It took me a really long time to work out how to pronounce that one, by the way. And so your lead data protection authority, which I'm doing a brief recap of the GDPR, is the data protection authority in the country where you have your single establishment. If you're a company that has just one entity but operates across the EU, great. Yes, you're selling goods and services into lots of member states, but you're still only dealing with your local data protection authority. Or if you have lots of entities across the EU, then the country where you have your main establishment. And it's this main establishment that was getting a bit more interest in 2017. The last bullet point is just to flag that this is only for cross-border processing, and so there is ultimately, inevitably going to be some interaction with local data protection authorities, particularly if smaller matters, subject access request, that sort of anything that's sort of an individual in that country, I'm sure will continue to be handled locally. So, main establishment, what does that mean? We got some Working Party 29 guidance last year on the idea of the lead data protection authority and how that would be decided and how it would work. I actually think it didn't go into as much detail as a lot of us would have liked about how the DPAs are going to work together, and particularly the question of sort of national laws and whether you might have DPA 1 advising on national law 2 and that sort of thing, but didn't really go into that, possibly because it's just a really hard question. But they did talk about the idea of main establishment and what that meant. Now, if we just go back to this slide, you'll see highlighted, it says, so if you don't have a place, if you've got a place of central administration, so an EU headquarters, tick, you're done. If not, it's the place where the decisions on the purposes and means of processing are made. Now, for all of you who know quite a lot about data protection law, as I'm assuming everyone here does, that sounds a lot like the controller to me. So then we got into this question of, okay, in fact, by main establishment, do you just mean the controller? And how does that work with the idea that you have multiple controllers around the group? Or else, does that mean you can only have one controller per group? And then the thing that happened there, I think, was that a lot of companies who were headquartered outside the EU started to get a bit scared. Because the idea was that you could still get the one-stop shop if you had entities in the EU. You definitely can't if you're just selling into the EU. The one-stop shop, not available. You have to have entities. But if you have establishments in the EU, do you get the one-stop shop? And does that require you having to prove that you have a sort of EU controller determining the purposes and the means? And particularly for US companies or companies with quite a sort of, if you're in the Asia Pacific or something, and ultimately most of your product design is done there, most of your decisions are made by your topco, where does that leave you? And the Working Party suggested that for groups that were headquartered outside the EU, where control in that sort of sense was exercised outside the EU, you could designate an EU establishment to be your main establishment. But we have also seen some reluctance on that part from the DPAs and from the Commission more informally. And all of this has resulted in some companies trying to push more control into the EU 27, because you've got US headquartered companies and you've also got UK headquartered companies who are suddenly thinking, do I have anyone in EU 27 who is actually determining the purposes and means of processing? And how do I go about sort of working out that tension between, okay, in reality, I just am a British or a US company, and so where my data protection impact assessments are done kind of makes sense that they're done where my products are designed. But on the other hand, goodness me, I don't want 28 different fines. So I really want to show that I have a data protection officer locally. I want to show that we do have some compliance on the ground in the EU. And so you are seeing more companies that are trying to shift more control to Ireland in particular is a popular place for the US companies to go, but just wherever they have a strong EU presence, really trying to beef that up in order to take advantage of the one-stop shop. So now I'm handing over to Brian.
Happy with that. Good hair. Okay, good evening everyone. Thank you, Hannah. So I wanted to talk about Schrems. Data protection top 10 here at Bristows wouldn't be the same without talking about what old Max Schrems has been up to. He's featured in every top 10 to date. That might continue, we don't know. So this year we're looking at the announcement that we will indeed have Schrems 2. So hardcore Bristows DP top 10 fans, about 10% of the front row I think, will remember that Schrems 1 appeared in the first publication, where a decision of the Court of Justice found safe harbour to be invalid. At issue this time is something we're probably all a bit more familiar with, the standard contractual clauses. Probably more importantly, something we're all a lot more dependent on than safe harbour. In terms of timing, we're probably looking at 2019, maybe 2020 before we actually get Schrems 2. So for those worried about Schrems not featuring next year, I can let you know that he has started a non-profit called None of Your Business, the objective of which is to make privacy a reality, which is essentially suing people. So I think we can expect to see more from Max next year. In terms of Schrems 2, in many ways was very predictable. When we think about Schrems 1, we think about safe harbour and the issues around how the Commission's decision was made, but sitting behind that, there were some very real complaints by Schrems about how Facebook was handling his data. Like every company that relied on safe harbour, Facebook shifted to relying on standard contractual clauses. And it was the natural next step for Schrems, and indeed the complaints with the Irish Data Protection Commissioner, to follow that. And so following the decision, the complaints were kicked back to the Irish Commissioner to investigate. And we found ourselves before the Irish High Court again, talking about data transfers, talking about Max Schrems, and talking about Facebook. The judgment begins, this is an unusual case. And I think that's quite an understatement. There were a variety of reasons why this is unusual. Firstly, the Irish High Court's decision to allow amicus briefs to be filed on behalf of trade industries, but also the US government. The US government making submissions, talking in some amount of detail about its surveillance practices, talking about PRISM, all going on the record, all going to be reviewed by the Court of Justice, not something that we're used to. And I suppose also just the significance of what we were talking about, the internet itself, how the internet works at the moment. All of these were unusual aspects. Probably most unusual, however, is the fact that we actually had a court case at all. In a rare moment of agreement, both Facebook and Schrems were aligned on one thing. The standard contractual clauses were valid. They were fit for purpose. Of course, they were in complete disagreement on everything else, with Schrems saying you need to stop flows of data, the standard contractual clauses aren't enough, and Facebook saying there was no issue at all. It was only the Irish Data Protection Commissioner that was pushing hard for this. When investigating the complaints, Helen Dixon came up against the standard contractual clauses and felt there was a serious question around whether these were valid, and she couldn't come to a decision without asking that question. And so she went to the Irish High Court, ultimately looking to get that question referred to the Court of Justice. And the Irish High Court agreed with the Commissioner, and to the surprise of some, but the issue with Safe Harbour was always around adequacy. It was a decision that was designed to provide for adequacy, and that decision was flawed. But everyone saw the standard contractual clauses as a tool designed particularly for a situation where you don't have adequacy, to provide safeguards where you're transferring to a country that provides inadequate level of protection. And the Irish High Court accepted that, but said just because you're relying on a derogation doesn't mean you step completely outside the scope of the directive, that individuals still deserve a high level of protection. So it's not enough to simply look at the standard contractual clauses and say we don't have to look any further. So on this, Schrems and Facebook again were agreed. They said, well, while the clauses themselves don't provide for protection, Article 4 of the decision that created these decisions does give a supervisory authority power to suspend data flows. Isn't that enough? Shouldn't that be enough to make sure that these contractual clauses are valid? And the Irish High Court said, okay, well, let's look at what Article 4 actually says. Article 4 refers to the general powers of supervisory authorities. It's general in nature. There's no obligation to exercise it. There's nothing specific about this power in respect of transfers or the contractual clauses. And the recitals of the directive talk about exercising the power only in exceptional circumstances. And the Irish High Court said, well, it can't be the case that you would have differing approaches from supervisory authorities throughout the EU, leading to fragmented approach and just people taking different enforcement action. That just can't be what was intended. Surely there should be a uniform solution provided for specifically for these standard contractual clauses. And on that basis, the Irish High Court said there was serious questions to be asked, and so referred the question to the Court of Justice, which is where we are now. In terms of, so if the standard contractual clauses were to be found invalid, and we are, I think, a long way from that position, the Irish Data Protection Commissioner said today that it'll still be a couple of weeks before we even know what questions are being asked. We still think there's, merit to the standard contractual clauses, and we don't see them being written off just yet. But if they were, what are the alternatives? It's difficult to point to one that is readily available. BCRs, still extremely difficult, maybe beyond the reach of many organisations, even though what people need to do for GDPR closes that gap a little bit. It's still a big undertaking. What else is there? Consent. The only real alternative is those who can benefit probably from Privacy Shield. And that's not going to cover anything outside the US. And in terms of Privacy Shield, things aren't going great, to be honest. There were a couple of challenges, annulment challenges, looking at the decision the Commission made, which have been struck out for lack of standing. And there was a reasonably benign report by the Commission which said to Privacy Shield, okay, not doing too badly, a lot more to do, but it's not on firm ground. And the Irish High Court decision that referred the question to the Court of Justice wasn't dealing with Privacy Shield, but there is a couple of interesting paragraphs in the judgment. The US submission and Facebook both went to great lengths to talk about how things in the US have changed. Laws have changed, rights are better, that because of Privacy Shield and the Privacy Shield Ombudsman, that generally things are getting a lot better for individuals in the US, and things are going to be a lot better for EU individuals to exercise their rights. Unfortunately, it backfired. The Irish, the judge said that, okay, well, thank you for telling me that. Firstly, Privacy Shield is not relevant here. And also, now that I've had a look, this ombudsman doesn't really offer an effective judicial remedy. I can't see how it's independent, and so it's not really of tremendous value anyway. And so things aren't looking good for Privacy Shield. But it will trundle along on political goodwill for the foreseeable future. So in terms of what would happen, we only really have one point of reference, and that's probably Schrems, or Schrems 1. And what did happen when Safe Harbour was invalidated? Not a great deal, really. There wasn't any major enforcement action. People moved to standard contractual clauses. And maybe it's an unfair comparison insofar as Safe Harbour was quite shocking to everyone. There was an alternative there. But I think what's important to remember is just how politically savvy the EU Commission can be when it needs to be. And I think if we got to a position where the standard contractual clauses were found to be invalid, we could expect to see some drastic action from the Commission putting alternatives in place, whether they're alternatives to Privacy Shield, new forms of standard contractual clauses, which they're already updating for GDPR. And so we're confident that the EU Commission would take steps to keep the show on the road. The elephant in the room here, of course, is the UK and Brexit, and Rosalie will be talking a bit more about that. But I think it's important to remember that the UK, at the moment, adequacy is looking difficult. It doesn't currently have a Privacy Shield equivalent, and it won't have the EU Commission at its back to help it out politically and commercially. And so I think the UK is in a difficult position. But I think to leave things on a somewhat positive note, I think one issue to watch for is the impact of GDPR on the issue of international data transfers and its impact on remedies for individuals and safeguards. Given the territorial scope of GDPR, exporting these rights globally, individuals much more readily available to take action against controllers or processors who've breached their obligations. It might be that the deficiencies in those third countries become a little less relevant when the Court of Justice goes to look at the question. And we could be in an unusual position where we have a number of large, almost every US organisation complaining about how difficult it is to comply with GDPRs, giving out about the rights it grants to individuals and all the work they have to put into it, to actually be singing its praises in a couple of years when they're saying, well, sure, US law doesn't provide for effective remedies, but we comply with GDPR, here are their rights. And so data transfers may no longer be quite the issue that it used to be. But given the last couple of years and given the ever-presence of Max Schrems, we think it's going to be exciting times ahead for data transfers, as always.
Evening, everyone, and thanks, Brian. So I'm going to be talking about ICO enforcement. And first of all, I just wanted to start off by saying that based on the enforcement action we've seen in 2017, we have not detected anything to suggest that there has been an enforcement culture change which has occurred in response to or in preparation for the more extensive fining powers the ICO will be granted under the GDPR. One interesting development we have seen, and which probably has which is more due to the new Information Commissioner rather than the GDPR, has been the ICO's tendency to issue public statements on high-profile and ongoing investigations, sometimes commenting on investigations even before an organisation has submitted its final responses to questions which the ICO has posed to it. Now, this strategy clearly highlights the importance the ICO has placed on having an open dialogue with the public and keeping them informed on an investigation while it is ongoing. And we expect this trend to continue into 2018. So, what does the year look like in numbers? Well, there's a few displayed on the screen, and I just wanted to mention the fact that the highest fine was for 400,000. This matched the record that was set by the ICO in 2016 when it fined TalkTalk for failing to implement appropriate security. The company that was fined this year for 400,000 was called Kaboom Communications, which ended up sending 99.5 million nuisance calls. And it's also important to note that this fine has actually been matched in 2018 because as of 2 weeks ago, the Carfin warehouse was fined, again, for failing to implement appropriate security, which led to a data breach. So, how does all this compare to previous years, and what conclusions can we draw from the statistics? Well, historically, ICO fines could generally be split into two categories. There were fines resulting from nuisance marketing, spam text, cold calls, etc., which are breaches of the e-privacy rules. And there were fines for breaches of the 7th principle of the Data Protection Act, where a company had failed to implement appropriate security, and this had then led to a hack or a loss of data, for example. Now, there was an unprecedented change this year, because 20% of the fines were for breaches of the 1st and 2nd principles of the Data Protection Act. This means that companies were fined for failing to process personal data fairly and lawfully, and failing to process it for a specified and lawful purpose. Now, this was all the result of the ICO's investigation into the charitable sector and some of the fundraising activities or tactics that we used. And this all follows reports in the Daily Mail in 2015. So the ICO found that tactics such as well screening and sharing data relating to donors were breaches of the 1st and 2nd principles of the DPA. And this led to 13 household names in the charitable sector facing fines that ranged from £6,000 to £25,000. And this action confirms what we were already aware of in theory but hadn't seen as much in practice. And this is the fact that the ICO will levy fines for a breach of any of the principles of the DPA, not just those relating to security. So, just to mention a few other cases that caught our eye in 2017, there were fines against well-known brands for sending emails which asked consumers who had previously opted out of marketing to reconfirm their marketing preferences. Note this was in a B2B context. And some of the companies fined included Money Supermarket and Flybe. The highest fine was actually for £80,000, so it was quite significant. And in the majority of these cases, the companies had embedded the request to the customer to confirm or update their marketing preferences in an email which on the face of it looked like a service communication. So it was entitled, for instance, updates to your accounts, updates to our terms and conditions. But then within the email, there's quite a big section which said, please update your marketing preferences. And in the case of one of the companies, they'd also offered the customer the chance to be entered into a prize draw if they changed and updated their preferences. So the action that was taken here is an important reminder that emails which ask customers to confirm their marketing preferences or to consent to future marketing will themselves be considered direct marketing, and they can only be sent to individuals if they've consented or if the conditions of the soft opt-in are met. Because in the case of these companies, they were all sent to individuals who either had opted out of marketing previously or for whom the company didn't have a marketing preference assigned to, so it wasn't clear if they'd opted in or they'd opted out. It's also worth noting that these fines came about because an individual complained, which suggests that individuals becoming a bit more informed about their rights, and they knew they'd opted out, and so when they received these emails, they reported it to the ICO. The other category of cases that caught our eye relate to breaches of security and the role of human error, or rather what the ICO might term lack of proper process or institutional failings. There were two notable cases. The first was Norfolk County Council, who was fined $60,000 after failing to empty an office cabinet before an office move. The cabinet in question ended up in a second-hand shop and was purchased by a member of the public, and inside it were sensitive documents relating to a child safeguarding case. Greater Manchester Police were also fined $150,000 after 3 unencrypted DVDs of interviews with victims of violent and sexual crime were lost in the post. In case you were interested, and these still haven't been found apparently, in case you're interested as well, the ICO said that if information of this level of sensitivity was going to be sent in the post, it should have been sent by special delivery or courier instead. So, to round up and to look forward to 2018, are we about to witness a sea change in enforcement under the GDPR? Well, the ICO has never levied its maximum fine of $500,000, and likewise there are many DPAs in Europe who have never exercised their fining powers to the full, or indeed have never used them. So to put it simply, the DPAs could already be doing more if they so wished. This suggests it's unlikely there will be an immediate sea change in enforcement. However, and it's quite a large however, with all the publicity surrounding the GDPR and the need for the new regime to be taken seriously, it is likely that over the coming years we'll see an increase in enforcement activity. This may be an increase in the number of companies or organisations that are facing enforcement action. It may also mean an increase in the average amount of the fines which are being levied. However, as is always the case with enforcement, part of it is a case of waiting and seeing, and it will be interesting to look at the statistics for next year.
Hello everyone. So as you might have noticed, GDPR is very easy to write about. I have counted probably 60 articles that I receive every month, and that's obviously just the sources that I use, including stewards, privacy laws and business, of course. So we have read some very interesting headlines. For example, last year's ICO fines would be 79 times higher under GDPR. Well done. Unsurprisingly, this came from a cybersecurity provider. Another headline is, as GDPR deadline looms, retailers must secure consent to access personal data. Oh dear, do they really? Another one reads, Wetherspoons just deleted an entire customer email database on purpose. Well, that one may be true. The headline message obviously is a bit exaggerated. Businesses do not have to do that in order to comply with the law. So all these headlines have created the desired publicity, but they also kind of created fake news about misconceptions about the GDPR, which we thought we would like to clarify. So probably the most favorite one is that consent will be required for everything. However, we know that there are alternatives, there are legal grounds that we can rely on. It is true that consent rules will be tightened, which may cause headaches for businesses which heavily rely on consent. However, for example, in relation to employment data, we can rely on contract. We can also rely on legitimate interest. Now, all these alternatives are subject to necessity, so they have their limitations. For example, with legitimate interest, we know that the controller has to carry out a legitimate interest assessment to make sure that the proposed processing will not infringe upon the rights, freedoms and interests of the individual. And this is where the GDPR is quite helpful. It has provided a list of perhaps a dozen scenarios where we could potentially rely on legitimate interest. Legitimate interest will not apply where the individual would reasonably not expect at the time of providing data that the processing would take place. And so this is where the consent requirement comes in. So it's not also gloomy, really. Of course, aside from this, there may be laws that impose the consent requirement, such as the marketing rules under PECA or the call recording under the Investigatory Powers Act. So the GDPR is trying to help. It has also created a new ground for processing for pharmacovigilance purposes. It also contains derogations that member states may want to make use of. For example, the UK will be reversing the rule that legitimate interest cannot be applied by public authorities. So it can be quite a complex issue, but businesses should definitely carry out a privacy impact assessment and record their decisions and the reasons for the decisions, just to have something to show for accountability later on. Another myth is that individuals have an absolute right to erasure. Now, we know that in practice there will often be reasons to retain data. For example, where someone, a company holds an address information to deliver goods. Obviously, request for erasure could not be complied with until the goods are delivered. And perhaps even beyond that, there may be a good reason, such as compliance with other laws, to retain that data. Another example is where email marketing is sent on the basis of consent. Now, when an erasure request comes in, the company would probably have to delete all that data that was processed on the basis of consent. However, it would not have to necessarily delete the email address, which may be needed to provide continuous service updates to the existing customer. Another one, when someone requests erasure of CCTV footage, again, the controller may find a legitimate reason to retain the data if there's perhaps an ongoing investigation. So it is not an absolute right, and it will depend on the circumstances. And it will often be the case that individuals will have to be remembered in order to be effectively forgotten. The next one is fines. So Emma covered this. I just wanted to add that obviously fines are not there to fund regulators, and if they decide to do that, then that's abuse of power. The best remedy for that is judicial review. And the GDPR does provide for judicial review. It guarantees it on a post-award basis in all jurisdictions, and any awards that are disproportionate could be challenged. And now, if the proportionality is assessed according to past awards, then perhaps that's good news for many of us if they have to consider the limits that have been applied to date, at least to some extent, to have some regard to those. Also, some jurisdictions are imposing pre-award judicial review, such as Ireland. So that's another comfort that businesses can take. Lastly, contrary to the headline that Europe is short of 28,000 DPOs, most private organizations will probably not even need one. As we know, for the private sector, the requirement is only triggered when the core activities consist of or are inextricably linked with regular and systematic monitoring of data subjects on a large scale. Now, this will kick in for the usual suspects, such as hospitals, CCTV service providers. It may apply to private spies or private research and due diligence companies, as they call themselves. Larger immigration consultancies. It may potentially apply to marketing and advertising agencies where the criteria are met. So generally the rule is, if your core business can be carried out without the data, then the processing is ancillary. And ancillary processing, including, for example, HR data, or including the usual marketing, will not trigger the requirement. Having said that, it would be hard to comply with the law without having a dedicated individual. So if it's not a data protection officer, perhaps a data protection manager, who can steer the project and make sure that the company is able to comply with all these requirements. Thank you.
So first, I just wanted to issue an apology because I think you are probably sick to death of people talking to you about Brexit. I think everyone is sick to death of people talking to them about Brexit, which is why it's no coincidence that I was given this topic as the most junior member of the data protection team. If it's any consolation to you, it was a bit of a pain for me to prepare this talk too, because my personal approach to Brexit at the moment is to completely ignore that it's going to happen, which is great for my mental health, but was made researching this a little bit more tricky. But even I have been forced to admit that Brexit is big news for data protection. And before we leave the EU, we really need to work out what our position is going to look like in the world with regards to data, and particularly with regards to data transfers. So, yeah, we can all agree this is quite important, but unfortunately, it's not quite at the top of Theresa May's to-do list at the moment. So far, things that have happened include a House of Lords position paper on the topic, which was actually pretty comprehensive and realistic. There was also our government's paper on it, which probably more on the optimistic side, safe to say, and there's also been a commission paper. But there haven't really been any practical, significant steps forward yet. The last thing to happen this month was the EU's announcement that Britain would be a third country when we leave. And what this means is that we'd be outside the current EU data transfer regime. But this is something that we'd kind of assumed already. So from our perspective, there are a heck of a lot of decisions still needing to be made. They're on a whole range of data issues, but I'm going to focus on two in particular, and these both relate to data transfers. So the first, predictably, is how are we going to transfer data to and from the EU when we leave? Now, as you might have heard already, our government is hoping to do this by achieving adequacy. And what this means is the European Commission issues a formal decision that a third country, their level of data protection legislation is essentially equivalent to that provided under EU law. This has already been granted to countries like New Zealand and Switzerland. And what it means in practical terms is that the data can be transferred to and from that third country and the EU with minimal restrictions. So, yeah, sounds pretty great. Our government are really keen, but unfortunately it might not be quite an easy ride to get there as we'd hope. The first potential issue is that, as has been mentioned briefly before, we might not even achieve adequacy in the first place. Many commentators have pointed to our privacy and surveillance laws, which they say are just too different from the EU's position for the Commission ever to give us this status. The second is an issue of timing. So you can't even start the adequacy process until you leave the EU. So what's going to happen in that gap between leaving and hopefully getting adequacy? What solutions are going to be put in place? What mechanisms to help businesses? That's a potential real problem. The third is that adequacy is not a status for life, and the Commission are entitled to withdraw it whenever they want. So say we start to deviate further away from the GDPR, further away from the EU's position on data, the Commission could just suddenly revoke our status, our adequacy status, and we'd be left in the same position as we are now. So it's difficult. These are just a few of the issues that we really need to start thinking about and start solving before we leave. The second broader topic I wanted to talk about was our relationship with the US, because unfortunately it's not just data transfers to and from the EU that are going to be affected by Brexit. We're really unlikely to be able to remain part of Privacy Shield when we leave, unless we join the EEA. So what happens then? Do we have to negotiate our own personal US-UK agreement? Who's going to do that? What terms is that going to involve? When's that going to happen? And is the current Privacy Shield model even the best one to be looking at right now, given that what Brian was talking about, given Schrems 1, given Privacy Shield's history and the failure of Safe Harbour? What's going to happen to onwards transfers of UK data which are already transferred under the current Privacy Shield framework? At the moment, we really don't know. And my kind of head in the sand approach isn't really going to cut it in the long term. Our government really needs to be working through these problems as soon as possible. And in the meantime, as practitioners, we need to be thinking about the kind of contractual solutions that we can put in place now to give our clients a bit of security, a bit of certainty in this really, really uncertain time. Okay, thanks.
Good evening, everybody. Okay, so in September of last year, just as we were all lamenting the end of the summer holidays, we were really cheered up in our office by the introduction of the UK Data Protection Bill. We were all emailing each other, very, very excited indeed. Now, at over 200 pages long, the good news is that only actually a portion of the bill is relevant for most of us, for most of our purposes. Quite a lot of the bill actually covers processing of intelligence services data and also the implementation of the Law Enforcement Directive. So I would say that there are probably two main aims of the bill. The first is to apply the GDPR into UK law, which is very important since the GDPR does give member states the ability to make its own decisions in relation to certain areas. And the second is to confirm that the GDPR will apply in the UK once the UK has left the European Union. Now, although there are no great surprises in the bill, there are, in my view, about 5 notable points of interest that I'd like to run by you today. So the first relates to the processing of sensitive personal data. Now, Schedule 1 sets out the conditions for processing sensitive personal data and data relating to criminal offence, which is much the same as is in the Data Protection Act 1998. But interestingly, it does add an additional requirement that data controllers that process sensitive personal data need to have in place a policy document. Oh, I'm sorry, just getting far too carried away with the excitement of this topic. Okay, so they need to have in place this policy document which explains how the controller complies with the data protection principles and also its policies around erasure and retention. So this might actually be something that over the next couple of months you may have to add as an item to your GDPR action plan. Next, automated decision-making. So the bill refers to automated decision-making as a prohibition, which reinforces concerns that the starting point for automated decision-making is that it is prohibited unless controllers can rely on certain quite narrow conditions set out. Now, this is different to the current law, where there's no prohibition as such, but rather it's something that individuals can exercise their right so that they aren't subject to decisions that are solely made by automated means. And this provision really is causing concern for many organisations, particularly those in the financial services sector, where thousands of decisions are being made on a daily basis via automated means, and they're now having to assess the legitimacy of those. Number 3 is children. So the GDPR leaves it open to member states to determine the age at which a child can consent to their data being processed by online services, as long as it's somewhere between the ages of 13 and 16. And as Faye said earlier, in the UK, as expected, the bill confirms that this will be 13 in the UK. Next, exemptions. So the exemptions from certain rules in the GDPR largely remain unchanged to those in the Data Protection Act. So we have the normal exemptions around crime and taxation, historical and scientific research, and so on. But when I was reading this week some of the briefing papers that the ICO has published in relation to its views on the Data Protection Bill, Elizabeth Denham pointed out that she was a bit concerned about quite a wide exemption that's in the Data Protection Bill concerning immigration, and this provides that various provisions of the GDPR won't actually apply, or you could exempt yourself in relation to the maintenance of effective immigration controls, which the ICO says is way too wide and could, for example, actually detriment individuals who are appealing asylum decisions and who want to access their data so that they can identify factual inaccuracies that perhaps happen during that asylum decision-making process. So they're very concerned about that, and it's something that they have flagged during the process, the legislative process that's currently ongoing. And then finally, I'll group penalties and criminal offences together. So the ICO's existing enforcement powers won't change although the sorts of actions they can take won't change that radically, but of course their fining powers are going to increase somewhat under GDPR. The existing offence of unlawfully obtaining personal data is going to be retained, but 2 additional offences are also created. The first is in relation to the re-identification of anonymised data sets, and the second relates to the alteration of data to prevent disclosure when responding to a subject access request. So it makes it a criminal offence to get rid of data that you don't want to disclose in your subject access request response. So finally, what next then? Well, the bill received its first reading in the House of Commons on the 18th of January. The debate hasn't yet been published on the government's website, and unfortunately I didn't have the chance to watch it live, sadly. But if the debate in the House of Lords was anything to go by, this bill will be hotly debated and contested from members of all sides of the House. Thank you.
Hello everyone, nearly there, number 2. The more eagle-eyed amongst you will notice that the Bitmoji in the back of your yellow book is different to the one up there, and that's because I did the one in the book first, realised it was horribly unrealistic, and then did it again. Now, something else that is horribly unrealistic was the European Commission's aspiration to get the e-privacy regulation done and dusted and for it to apply in May this year, along with the GDPR. I put up there the timeline, the incredibly opaque legislative process in Europe. We haven't really entered the formal trilogue process yet. And the first draft came out in January last year. So if the GDPR is anything to go by, it's got a very long way to go because not a lot has moved on. There have been some changes, and I'll talk about those in a minute, but I've put a table up there which shows some of the main bits of paper that have been published. It's most certainly not everything. What isn't up there is on the 11th of January, we actually had a paper from the Bulgarian presidency where they commented on some of the discussions points. All they basically did was highlight a load of things that still need to be discussed. I think there's another meeting of the relevant working party scheduled at the end of this month. So a lot of negotiation, a lot of discussion, but not a lot of progress, and a lot of lobbying. That's probably been one of the defining characteristics of the e-privacy regulation, the dizzying amount of lobbying that's gone on. You have the online advertising industry furiously campaigning to what they see as a very conservative and restrictive piece of regulation, which is basically going to shut down ad tech and programmatic advertising, all those types of things. On the flip side, you've got the privacy advocates and the fundamentalists and so on in Brussels who are absolutely outraged by being tracked online and having handbags displayed to them because they looked at one on John Lewis and so on. So that's probably one of the biggest things that I've noticed about the e-privacy regulation, the lobbying. So in terms of what the open points are, again, this isn't everything, but some of the key things and probably the things that are of most interest to the people here. So the first thing to note is that the fines, it's an equivalent regime under the GDPR, so the fines are the same. Obviously, fines are very high profile. There are differing opinions as to how theoretical they are, whether they be enforced. It varies regime, market to market, and so on. However, it does mean that things will be taken more seriously because it's an equivalent regime. The other big ticket item is the expanded scope, so what's referred to as OTT, over-the-top providers, messenger services, things like that. They're brought within scope of the confidentiality of communication bits. Still open to debate, but it's likely that they will be caught. Well, what isn't clear is what does being caught, what does that actually mean? Consent is another theme running through the regulation. What is the case is that consent, so when consent is required, and it's a moot point as to when it might be, that is GDPR level consent. So all the bells and whistles that come with Article 7 of the GDPR that we're all debating when we're talking about marketing, repermissioning, all that type of thing. That's obviously very challenging in an ad tech environment when you think of how difficult it is to get genuine, robust, valid consent under the GDPR, and that is an ongoing debate and something that is being so heavily lobbied, particularly around cookies. So in the cookie context, one of the biggest changes and the thing of most confusion under e-privacy regulation was this escalation of cookie consent to the browser level. What the Commission had wanted to achieve was a simplification of the rules and to have it all covered quite easily and in a very consumer-friendly way by dealing with it at the browser level. The problem is that individual publishers could override that and get consent from consumers if they wanted to. So you probably get more consent requests. What I noticed that actually in the most recent position paper from the Bulgarian presidency, it looks as though that position has actually come back quite significantly, and all the ad tech industry and the online advertisers who've been lobbying seem to have had some success because, for example, in some of the early drafts of the e-privacy regulation, there was even talk of legitimate interests being available for cookies, and you didn't need to get consent at all. They're now discussing that again. That type of thing appears to have gone back on the table. The other relevant part is tracking walls. So the privacy advocates have been campaigning furiously to basically prohibit digital and online services from requiring people to consent to cookies in order to get access to the service. That's persisted through successive drafts of the e-privacy regulation, but it seems, again, much like the cookie consent mechanisms, that's come back a bit, actually, and in the most recent paper, they're even talking about removing it completely. But again, it's very much an open point. The last thing I wanted to flag was direct marketing, or electronic marketing, as it would apply. One thing you may be familiar under the current e-privacy directive, B2B marketing, so sending marketing to people at their work email address, that's not within the e-privacy directive under Article 13, but member states can broaden it out to B2B if they want to, and many, not all, but many have. The e-privacy regulation is expanding that as the baseline, which would apply across Europe, so B2B would be in scope for everyone. Currently in the UK, it's not in scope, but it would be if the e-privacy regulation comes in, although, again, open to debates. The other slightly complicating factor, particularly in ad tech environment, is the definition of direct marketing. Many of the drafts have added words like presented and served to the definition of direct marketing in addition to it being sent. The reason they've done that is clearly to bring targeted display within the scope of the consent requirements of direct marketing. Now that's very strange and very confusing in an ad tech environment where we already require consent for cookies. What does that actually mean if direct marketing is also targeted display? Whether that will make it into the final version, we're not sure. It's being heavily lobbied and heavily debated. Thanks very much.
Thank you. One of our managing partners saw that and said he's got more hair than you, which I thought was outrageous, really. So the thing about giving you the book beforehand is that for those of you who see data protection as a bit of a thriller, it kind of kills the suspense in that you already know that accountability will be number one. And the question is why? It's just a piece of the GDPR. Why would that be number one as opposed to anything else? Well, I think the reason is that that's probably the reason that many of you, well, it's kept us busy for a few years now, and it's kept a number of companies very busy for a long time. And it's ultimately what's behind the introduction of the various privacy programs that they're introducing. So when I say data protection has moved on, many in the audience who've been doing this a very long time, there was a time when data protection looked a little bit like HR, just don't tell anybody whatever crosses your desk, just keep your mouth shut. And from a marketing point of view, a bit of small print and a tick box, job done, that was data protection. And now here we are, I mean, just a number of you in the room and people we talk to would be big companies that have implemented a whole change management program to re-engineer their business and their business processes and their compliance stance on things to satisfy GDPR. And that is a massive transformation. And it's driven by accountability. And it's worth just calling out one of the significant changes. So if we think about the existing law at the moment, what does a breach look like? A breach, roughly speaking, involves doing something wrong with data. lose it, misuse it, do something. You need to screw up with data. Under GDPR, all that stuff is still a breach. But then there's also this principle of accountability, which is to be in a position as an organization to demonstrate that you've got your data under control. A failure to be able to demonstrate that would itself be a breach, quite apart from whether you actually lose or misuse any data. Now, if you don't lose or misuse any data, maybe nobody finds out. But you could get asked, it's possible. So it's sort of changed the nature of the obligation, changed the nature of breach to some extent. I'm struggling here because I can't see it down there. I can't see it down there, up there. Anyway, we are a little bit short on time, so I'm going to skip over how to get there. And I'll just say, every law firm, every consultant, everybody, anywhere who's doing this stuff as an advisor has their methodology. And everybody does. We have ours. We prefer some to others. I was just going to take you through the various steps. But happy to talk about it if necessary. But I think we'll just get a bit of time back by not doing that. So where we're trying to get to with accountability is to, as I say, a bit of change management. So the company has a system in place to handle data in the same way as it might other compliance issues, whether it's ethics or certain types of public procurement, whatever it might be. It needs to move from keeping its fingers crossed about how it's handling data to something a little bit more deliberate. That can involve lots of things, training, people, but it does involve some paper as well, usually, or at least the electronic equivalent. So there will be some policies, there will be some controls, there will be some internal guidance setting out what people should do. So we spend a lot of time preparing documents for the HR function of our clients, so they are user-friendly, they can follow that document, and they never have to worry about GDPR again, because that document describes their process, which, if it's followed, will achieve a level of GDPR compliance. That's, I guess, what everybody does. The first bullet point here, though, is saying, well, this framework, it needs to fit culturally. And you can really, really spend a lot of time, a lot of money as a company coming up with something that looks awesome in terms of GDPR compliance, but which just doesn't take root in the organization because that's not how it's used to handling issues. So I'm not going to name any names, but I can think of some tech companies where we were asked to do a compliance program with nothing written down at all, which was a bit of an ask, to be honest, because that's kind of what lawyers do. But the idea that you so essentially talk to them about, well, how do you handle other issues? What do people respond to? Do you have a large engineering team, which is typical of a lot of our tech clients? They're not going to sit there and read lots of manuals or detailed policies or anything like that. So finding creative ways to have the most impactful approach to this is really what this first slide is getting at. And just things we've seen along the way. So I think I will admit on behalf of the team that people are a little bit wary of GDPR, as I know a lot of people in the audience might be as well, because there's a lot of stuff to do. And the reason for that is we've done dozens and dozens of these now. And so what have we seen? What are the tricky areas? Well, contracts. So we talk to some clients. Every now and then we'll be surprised and they'll say, oh, we've only got 4 vendors. And that is a real hallelujah moment, because a lot of them will say, we've got over 10,000 vendors. And many of them are data processors. Some are controllers, can't tell which. Some are both, don't know. What do you mean we've got to amend all those contracts to be GDPR compliant? How do you do that at scale? And that usually turns into a conversation around, well, how do you prioritize? Which are the key ones? You've got 10,000, but maybe there's 20 that are responsible for 80% of your business and your risk. If you can focus on those, that's the place to start. How do you amend all the others without, let's say 1,000, let's be modest. How do you amend 1,000 contracts without getting 1,000 signatures? So what you may have been on the receiving end already. We're seeing a lot of sort of corner cutting in a way, because you've got to, because there's just no other way of doing it. And people are handling contract amendment the way you might novation after an M&A situation, where you're sending a letter, you're saying, here's the terms. They stick unless we hear otherwise from you. I mean, it's far from perfect, but that's the only way of handling that volume of contracts. What else we got? Lots. Yes. Third-party IT systems. So depending on the nature of the obligation that you're trying to implement, and of course depending on your sector, depending on your business, you may be heavily dependent upon a cloud provider, software as a service provider or something like that, where what is done with the data, the functionality that you are using, and therefore your ability to comply as an organization just depends if it's there out of the box. So sometimes it is, sometimes it isn't. You're sort of hoping that if it's a big vendor with a big EU customer base, that this is going to be an issue for them, a sales issue, and they're going to want to change the product. So eventually, the pipeline will include something that makes it compliant, but not necessarily. Consent, that comes up all the time. We're seeing, for example, on the employment side, I think it's kind of interesting. I think as a group, we've been off consent for employment for a very, very long time, and having a broad consent statement in an employment contract that people sign has felt like not such a good idea for a very long time. But now we're seeing that under GDPR. People are moving away from consent, at least in an employment context, fairly quickly, I would say. We're seeing those consent clauses come out of template employment agreements because GDPR says it's got to be separate, it can't be buried in other terms, it's got to be capable of being revoked. Then we've got the whole is it freely given thing. And then we have questions about, well, should we re-permission our entire database? We got 100,000 or 1 million, 10 million, whatever, people. We've been sending them mailings for years. We did on the basis of consent. Should we write to them and ask them to consent? It's a really good way of emptying your database if there's people you don't want to hear from. But that comes up quite a bit as well. Data retention. Oh my goodness. So I don't think it's an exaggeration to say that I'll say virtually no one. So if there's anybody in the room, you can put yourself in that it wasn't us category. There's virtually no one who's got data retention sorted. So we'll go through these sort of workshops with multinationals and say, so how long do you keep your data for? And we've written down forever, even before they answer typically, because storage is cheap. Weeding it out is difficult unless it's something that's automated that you can do at scale automatically. It's very, very difficult. But what's interesting is we are seeing, as part of people's preparations for GDPR, a very strong focus on retention. People are doing a bit of a spring clean or thinking about it anyway. Some of that, I think, is driven by the fact that there's data retention obligations, data deletion obligations are not new, of course. The new bit, to some extent, is there are circumstances where you may need to communicate when you collect the data when you're going to throw it away. So if you haven't made that decision, you can't do that, and your silence on the question of how long you keep data for, particularly for certain online services, will become more visible. So we're seeing quite a bit of work, and when I say deletion, I'm sort of bundling in anonymization. We're seeing a lot of conversations that go, well, we can't throw the data away. It's our entire business runs on the analytics that it powers. How do we anonymize it enough to be able to meet this requirement? Staffing, we get asked about that. You'll have all have gone through that. Do we need a DPO, which we heard about from Alex? Sometimes yes, sometimes no, obviously. But the question about, well, reporting lines, how many people, it's really interesting. The amount of looking around there is between companies. Well, how many, have they really got 200 people doing data protection? There's only me. Is that real? And so we get asked that a lot of benchmarking about the number of people, the distribution. Do you have one per country, one per geography, one per business unit, whatever it is? People are thinking about that very, very carefully, and people come to different conclusions. But what we haven't seen a lot of is, we'll just do the paperwork and we don't need anyone. There seems to be a starting point, which is you might want to minimize it, but you're going to need somebody to run this program. Otherwise, you'll sort of snatch defeat, really. You'll do all this hard work and then it won't be brought to life internally. Privacy impact assessments, I'm not going to say a lot about that other than the trigger point is what we see varying from client to client. So what is a level of risk that would warrant a full-blown privacy impact assessment? And that varies from company to company, of course. But what's interesting is we see companies that have got it wrong. And they'll have a because they've gone early and they've done it a few years ago, and they might have a backlog of 200 or plus PIA requests sitting on somebody's desk that they can't possibly get through because they're trying to do a privacy impact assessment for absolutely everything. So adjusting the level of sort of, what's the severity level, if you like, when it should hit the privacy office so they can do something more thoughtful. Data mapping, yes. So I've got a bit of a hobby horse about this, and we're running out of time, so I will spare you. But the idea that you need to go in and find where every last atom of data is down the back of every last sofa before you can do anything to move in the direction of compliance doesn't make any sense at all. You'll just waste a lot of money, spend possibly years, and at the end, the one thing you'll know for certain is that you're not compliant, which you probably knew at the beginning. So, so there is, of course, you need to understand your data, but you need to, we would say, you need to keep in mind, what are you trying to accomplish with the data mapping? Are you trying to understand your data enough that you can develop a compliant and relevant program to protect it? Or are you trying to do some sort of IT security exercise? If you're trying to do that, you might need to know where everything is. So you can think about firewalls and encryption and all the rest of it. Or are you just trying to do your Article 30 register? So everybody's got to do that. So there's a level of mapping that's required. But I would commend the ICO template to you, if any of you haven't had a look at that yet. That is strongly suggesting that you can go pretty high level in terms of your description of the processing that you do, and you do not need to spend 6 to 12 months mapping everything just for that purpose. And then we got data transfers. That can be tricky. I'll move on from that. If you're going to build a program with the intention of going BCRs at some point, it's better to decide that at the beginning, because the documents you would use would need to be BCR flavored, and it's much easier to do that at the start. Right. We are still getting calls from companies, some surprisingly large, who've literally done nothing. And so the question I get asked, probably most internally, at least by my partners, is this all going to end in May? And we don't think it is going to end in May. The way we're thinking about it is there'll be the long tail of those who are slow starters. They'll all still be thinking about it. And also, to the extent you've taken the company and made it this sort of accountable, thoughtful data protection organization, it's like data protection has sort of woken up inside the organization. So unfortunately, I think, maybe fortunately for us, maybe not, unfortunately for others, there will be probably more to do. For those who've done nothing, 120 days is not long, but you don't throw your hands up and think, right, we're defeated, let's not bother, let's just sit back and wait for the enforcement action. I think what we would say is there's enough time that you can do something meaningful, but you would need to adjust your methodology so that you've done the most impactful things in those 120 days. So if you, for example, if right now you say, right, here we're ready, let's go, let's do a big data mapping for 6 months, after 120 days you will be no more compliant then than you are now. So maybe that's not the way to do it. You might say, okay, well, 120 days takes us a long time actually to develop a policy and agree it and all the different stakeholders involved. On the 25th of May, we at least want to look compliant from the outside in. We want to look shiny and GDPR'd. So let's do that. Whereas for the companies we've been working with for a year or two, that might be the last thing they do. Because you don't want to put up that notice that informs people of all these extra rights and complain to the ICO a year early. So a lot of people are doing their notices towards the end. If you've done nothing, of course, the end is sort of the beginning for you in some ways. Anyway, it's a case of reordering everything. Don't panic. Do the other stuff, but just shuffle the order. And I will leave it there. Well, it just remains for me to ask you, please, to thank members of the Bristows Data Protection Team who were the speakers, some of whom I've got the full range from junior through to very senior. And thank you all very much for coming and for listening. And again, please feel free to join us for a glass of wine. Thank you.